Thanks for joining, everybody. I am Belinda McCauley. I'm the Executive Director of the Beverly Hills Bar Association. I want to welcome you today on behalf of BHBA and our co-sponsor, the California Lawyers Association. If you're not already a member of both BHBA and CLA, I encourage you to join. I'm going to introduce our speakers briefly and then let them get to their expertise because they have a lot to talk about today. Carole Buckner is a partner and general counsel at Procopio in San Diego. Her practice focuses on legal ethics, and she has held virtually every ethics leadership position that you can in the state of California as an attorney. She's a regular speaker on these issues, and we're delighted to have her with us here today. And joining her is Rachelle Cohen, who is a partner at Kehr, Schiff, Crane, and Cohen here in LA. She specializes in corporate transactional law for small and medium-sized businesses, and she regularly speaks about those issues and about professional ethics, and we look forward to her insight today as well. The COVID pandemic and all of the closures associated have really fast-tracked remote work, as we all know. And that brings options for people and in some cases improved employee morale and flexibility. But there are also considerations that as lawyers we have that other professions don't necessarily. And so Carole and Rachelle are going to walk us through what the applicable rules are, some hypotheticals, and share the expertise they've been building throughout this last year in these very strange times. So I will start with you. Thanks so much, Rachelle.
Thank you, Belinda, and thank you all for joining us here. I wanted to start out initially, take a step back and thinking about the ethics rules that apply to lawyers. And the most recent version of the ethics rules became effective in November 2018. So that's already been a few years. The version before that became effective in 1992. So as you can see, the ethics rules don't change that frequently. That's in California. They don't change that frequently, and they're based on what's known at the time. You know, and that's often the case with laws, that they're developed and then the world happens, right? And we have different technologies, we have different ways of practicing, and then the environment around us changes, and those ethics rules still apply to us as attorneys, even when the world around us has changed. And that's the challenge here. Especially now during this COVID time, to look at the ethics rules that nobody imagined would be applied in a situation like we have today. And so we're going to go through some of those issues that might be coming up for some of you, you might be hearing about, or some of your clients, and sort of walk through how to think about these issues that are coming up with the ethics rules that we have and the guidance that we have today. So I'm going to start out in thinking about what happens when a California lawyer is practicing out of state. Now, I'm sure most of us have done this, right? You go on vacation, maybe you go to visit family in New York, you spend a week there, and you bring your laptop, and you might have to have a client call while you're there. So you're taking a vacation, but you know, for many of us lawyers, even when you're on vacation, you're doing a little bit of legal work, and you might be doing it out of state. And that's, you know, been since we've been able to take our practices with us remotely with our laptops and speaking on the phone with clients, we've been able to do that. This is a different time. And I think as an example, I was thinking of the let's say you have a lawyer practicing at a firm in Los Angeles. That firm has closed its offices temporarily, maybe not so temporarily, and they're living in an apartment with 3 roommates, which all worked well and good when the roommates were all leaving the house to go to work, and the lawyer was also leaving the house to go to an office to work and coming home at night and maybe working a little from home, but now is working fully at home with a few roommates in a cramped space. That might be a time when someone would think, maybe I should move to a different location. And some of the options might be, maybe I go back to Utah where I have a sister living and she has plenty of space in a big house, and I can take a little area to live in and work, and it's going to be comfortable. And so if a lawyer does that, first of all, is that an issue? And the issue that immediately comes up is whether the lawyer is engaging in the unauthorized practice of law. Now, I think most of us, when you're thinking about UPL, you're thinking of non-lawyers practicing law in California. Well, that's not only the case. It can also apply to lawyers when they're practicing law in places where they shouldn't be. And then the question is, when does that come up? So the ABA came out with an opinion recently, and we included that in the materials for today. So that opinion is extremely helpful and talks about, do the unauthorized practice of law model rules apply in that situation when a lawyer is working outside of the state? Now, one caveat here, and I think Carole would bring this up if I forgot, but that the model rules don't apply anywhere. So, as you know, ethics is state by state, as is lawyer regulation, right? So if you're licensed to practice law in California, you're following the California ethics rules. And there's no federal licensing or federal ethics rules. But the ABA has come out with model rules, and all of the states, I believe all of the states, model their ethics rules after those model rules. But none of them is exactly like the model rules. So in California, we have many variations from the model rules. You can't just look at the model rules and say, I know what to do in California. You have to look at the California rules. And that's the case with UPL issues, with any sort of ethics issues that you're dealing with in another state. If you are moving temporarily or for some period of time because of COVID to Utah, you need to look at what Utah says and not only rely on the model rules.
And I can make another quick point here, Rachelle. Other states also have statutes, just like California has statutes that apply to the unauthorized practice of law. Other states may also have statutes. They may have unauthorized practice committees on their bar association. So we've got 50 different systems of regulation for people to think about.
Yeah, thank you, Carole. That's a very good point. So the starting point when I was looking at this question is can this lawyer who's licensed only in California, we're assuming, practice in Utah? And California's rules say in 5.5A1 that a lawyer admitted in California may not or shall not practice law in a jurisdiction where to do so would be in violation of regulations of the profession in that jurisdiction. So they push you, the California rules push you over to Utah. What does Utah say? Well, I'm not going to look specifically at Utah because this is more broad-based, but looking at the ABA model rule 5.5A, and this is again discussed in the ABA opinion on 495. The question is whether, this is in 5.5 model rule 5.5B, is whether the lawyer has established an office or other systematic or continuous presence in the jurisdiction. So in this case, in Utah, have they established an office? And the ABA really focuses on that established language. Have you established an office? And they take the position, if you're in a state, practicing not holding yourself out as having an office, then that's not establishing an office or a presence in that jurisdiction. So if you're working from your sister's house, let's say, and you're not holding yourself out to anybody as having an office in Nevada, then you, under this opinion, wouldn't be establishing an office in the state. And then they also look at the holding yourself out, and that's, are you using that you're in Utah in any way in your practice? So if you think about that, on your website, does it still have, I'm licensed in California, that sort of language, and the office address? Do you have a Utah office address listed there? Maybe for, you've put in your sister's house, or maybe you actually have rented a space so that you can work there, and you've put that on your website. Well, all of a sudden it looks more like you're holding yourself out as having an office in Utah, and that would potentially violate the UPL provision. And then lastly, there's a provision in the model code about temporarily practicing in a state. And the question there is, what's temporary? And, it's possible a lawyer moved thinking it was very temporary. In the beginning, I think we all thought, a few weeks and we'll all be back. And so they might have made a temporary jump to another state. And now that's become a little less temporary, perhaps. Or if a firm has closed their office, is a lawyer considering staying full-time in another jurisdiction? Carole, did you have something to add?
Well, I just wanted to say that a lot of the terms that are used, temporary is a good example. Holding out is another good example. What these terms mean is not incredibly precise. So you do have to be careful, because what you may think is temporary, I'm only staying here for a year, the bar may think is continuous and systematic. And then you are in a position of potentially violating the rule. So these terms are not well defined. It's just something to be aware of.
Good point. And I think, I was thinking, how could you really get in trouble here? And it's easy to think, okay, your website, you're not going to put another state's address. That's easy to control. But I wonder if you have thoughts on this, Carole, but I was thinking, if you're living in Utah now, and let's say, maybe you grew up there, so you know some people in the town, and you're going to the market, and someone sees you with your mask on and they still recognize you, and they say, hey, what are you doing back in town? And you say, oh, I'm just here for a while, my law office is closed, and so I decided to come here. And oh, you're a lawyer? And then, of course, we all know, the cocktail example of, you get thrown the question, and that's something that we all are sort of on notice, whenever we go to a party or something. Are you taking on a client when somebody asks you questions like that? But I wonder if that would impact the analysis if you're going around town and people start to know that you're a lawyer and start asking you for advice. That gets into tricky territory.
Yeah, I think, some states have what we call the Snitch Rule. And in those states, lawyers have an obligation to snitch out somebody else to their bar association if they're violating any rules, any ethics rules. We don't have that in California, so we don't think that way. But I have had situations and represented people dealing with the State Bar of California where a competitor made a tip to the State Bar that so-and-so seems to be in California and practicing law here or there and not admitted to practice. And so that's one way it can come up. Another way is if you're handing out any business cards, or as Rachelle said, if there's something on your website. Another way is if you're applying for a job and purporting to, be able to practice law. That's a situation where somebody who's a lawyer in that in that location might have an obligation to report you. So it can come up in a lot of different ways. California has a Unauthorized Practice of Law task force. They're prominent in, looking into that topic. And so they have a complaint system where you can make a complaint to them. So this issue can be raised in a number of different ways.
And a question came up that if the California lawyer moves to Utah during the pandemic, but works exclusively on matters that are based in California, would that be problematic? And that's, so the lawyer presumably would be only practicing California law. We're assuming that the lawyer is not practicing Utah law, because then there is an issue. But even if they're only practicing California law, the question is whether they are establishing an office. And again, I didn't look at Utah law to be able to answer this, except Utah in the ABA opinion is one of the states that has come out saying it's okay for people to come here and practice law without becoming a member of the bar if they're not. And I don't know what the qualifications of the opinion are, but let's assume it's that, they don't establish an office. So that whether the lawyer practices only California law or does tiptoe into practicing Utah law, that is an issue. So if they're the requirement would be they're only practicing the law of the jurisdiction in which they're licensed.
And the ABA's opinion, it does say that if you confine your practice to California law, then if you're in a state like Utah, and they also mention the state of Maine, where that particular state has no problem with you as a California lawyer being physically there, as long as you are doing California law, then the ABA's new opinion says that's fine. Just beware. The opinion mentions Utah and, as I said, Maine. We've got each state deciding this issue for itself. So when you're looking at where can I go, which is the question I've been getting a lot lately, where can I go? I recommend people look at the particular state, and there are ethics lawyers in every state who can tell you very readily what is allowed in that state. You could also research it yourself. You could call the bar association in the particular state, just to make sure, because some states do still follow what is known as the butt in the seat rule. I did not name this rule, but it basically says if your butt is in the seat in the state, you are practicing law in that state, and we regard you as practicing law, and you would need to be licensed in the state. So states vary. Check it out wherever you're thinking you may want to go. So now I'm going to segue, if it's okay with you, Rachelle, over to, let's kind of flip the hypothetical here. Now let's talk about an out-of-state lawyer. Let's say somebody's admitted in the state of Utah, and now they're going to come and work in California during the pandemic, or even not during the pandemic. They're going to just come and start working in California. The California State Bar did adopt Rule 5.5, as Rachelle indicated, and the provisions are very similar. But a lawyer who's going to do that, come from another state and start working in California, needs to be very careful, just as we were talking about with the reverse. The rule says a lawyer who is not admitted to practice in California shall not establish or maintain a resident office or other systematic or continuous presence in California for the practice of law. Now, some people have said this rule should be changed due to the pandemic, and I really can't argue with them, because we just don't know what is a systematic or continuous presence. But if I'm going to move here and I end up living in California for years, and I'm practicing law, even out into my home state, let's say it's Utah, then I think I'm at risk. if I am going to be here with a systematic or continuous presence, even if I don't establish an office, which is also going to be problematic, I still have a systematic and continuous presence in California for the practice of law if I'm practicing law here. And so, so that is going to be a potential issue. In California, we also have, and other states have similar statutes in some cases, we also have the Business and Professions Code. And Business and Professions Code makes it a misdemeanor to practice law without a license in California. So if you end up doing that, you're probably going to, sooner or later, you're going to be at risk of getting a letter from the California State Bar that says, wait a minute, you're not licensed to practice law here in the state. And usually what they would do is tell you to cease and desist from the practice of law. And then they're going to give you a warning. And the next thing they're going to do after that is mail a copy of that letter to whatever state you are licensed to practice law in. So you're here from Utah, you're here from New York, then the New York bar, the Utah bar, wherever you are licensed, will potentially start investigating what is it you're doing in California. Are you practicing law in California? Because they have Rule 5.5, some version of it as well, that says you cannot go into another state and start practicing law. Now, this new ABA opinion does give you some cover if you are going to do that, because the ABA opinion does say, as long as you're not holding out, you don't have a website saying, hey, now I'm in California. If you're not licensed here, you are not establishing an office, you're not having a systematic and continuous presence, then potentially you have cover by this new ABA opinion, which says, as long as you're practicing the law of the state where you are admitted, then California should have no interest in regulating you. Now, I have to say, California has not said that. The ABA has said it. And those of us who work in the field of ethics, we know that the State Bar of California and the American Bar Association do not agree on everything. And so California may still want to enforce its rules and get into what is a systematic and continuous presence, get into what is holding out that you're licensed to practice law. So we have a couple questions here. Can a lawyer practicing federal law only practice from another state without engaging in the unauthorized practice of law? Yes, with a couple caveats. And the question says, for example, federal, trademark, copyright. I would also add to that patent law. I would also add to that immigration law, possibly also bankruptcy law, federal tax law. So there are a lot of federal areas of law that you can practice in a state where you're not licensed. There are a couple of cases that say California does not, the State Bar of California does not regulate the federal practice of law. Who regulates that? Federal law. And so there is a caveat to that, though. And I do think if you're going to do that, that you want to be super careful about exactly what you're doing. If you start doing bankruptcy law or even immigration law, for example, you may find that some of your work causes you to venture into the state's law because it's very hard to do bankruptcy advice without contracts. It's very hard to do immigration advice without family law or criminal law or some other areas of law that are strictly state law. And once you do that, then guess what? You're practicing law within the state and you're practicing the law of the state. So if you want to do federal law, you have to be super careful and restrict yourself solely to that federal law if you're doing it in a state where you are not licensed. Rachelle, did you want to add anything on that?
No, I think that's a great point. I think that also, you can apply that same sort of idea that if you're practicing federal law, there's that risk that you're going to slide into state law at some point just based on issues that come up. And I think that's, if you're in a state long enough practicing another state's laws, so you move to California, but you're not a California lawyer and you're just practicing out of state law, it's possible you'll also develop relationships and where things come up that are California law based, and that's that is a concern that you then are engaging in UPL.
So we have another question here, and feel free to ask questions during the presentation. We'll try to handle them. Both Rachelle and I are fine with that. If a California lawyer is on a short trip to visit his mother in Oregon, and during the trip he participates in a virtual mediation on a California case, and since it is by Zoom, no one knows where anyone is he allowed to participate while in Oregon? And does he have a duty to advise the mediator and the other party that he is in Oregon? Well, I guess I'll let Rachelle weigh in on this as well. My first thought is, what would Oregon say? This is where we get to the point of multi-jurisdictional practice is somewhat archaic in view of the technology that we have. And our rules, as Rachelle said, have not kept up with that whatsoever. So I do not know if Oregon would care. As far as California is concerned, if you're practicing California law for a California client, and you're admitted to the practice of law in California, I don't think they're going to have any problems. But I don't know what Oregon will say. Rachelle, what do you think?
Yeah, I think that, I think so many of us have taken little trips like that and done things like that, spoken to a client on the phone while on vacation, like I said, and I don't think any of us really, maybe there's some ethics geeks out there that really have thought about this, but I don't think any of us have thought about that as being, something that would be UPL. And so my inclination would be this falls in that bucket of, it couldn't be considered establishing an office or a systematic presence, but I agree with Carole, you need to look at Oregon to be sure of that.
Yeah, and all I have found in looking at different states is I'm always surprised because I can't tell you, some states are very generous with they want more lawyers to help their population. And so you can do that very readily. Other states seem to me to be more protective of their lawyers and are more restrictive. So that is something that we all have to be very careful about it and be aware of.
And one question that the person also asked was, do you have any requirement to notify the other parties, the mediator, that you're out of state? And I only raise this because there might be a duty to notify your client if it's something significant under like California ethics rules. I'm not aware of anything that you have to notify a mediator or the other side. I don't know if you know of that, Carole.
I don't think you would unless it is material. And it's probably not material under the hypothetical. I think we could be doing Zoom from anywhere now. But again, just whether Oregon would say something different, I do not know. Okay, so we've talked about the out-of-state lawyer in California. One more thing I want to mention about that. California does have a set of California rules of court. And these are mentioned in the notes, in the comments to Model Rule or California Rule 5.5. And these California rules of court allow lawyers to, from out of state, to practice law in California if they follow the particular rules involved. And they govern pro hoc vice, they govern military counsel, they govern out-of-state attorneys who are doing arbitrations, they govern registered in-house counsel, registered legal services attorney, attorneys practicing temporarily in California as part of litigation, and non-litigation attorneys temporarily in California to provide legal services. So maybe this is the flip side of the last hypo. You're temporarily here for some purpose. What do you have to do? Go look at the rule. For example, registered in-house counsel. Let's say you're going to work for a company when you're here. The registered in-house counsel rule would have you register with the State Bar of California. They're going to do a little moral character on you to see that you're of good standing and make you file a moral character application. And if you don't register, then technically you have violated that rule and you are engaging in the unauthorized practice of law. So if you're from out of state, you're going to do something in California, don't put up an office, don't hold yourself out. Look at the California rules of court that require you to register for certain types of legal activities and comply with those rules. Shall we shift gears now, Rachelle, and talk about the pandemic-related issues that are coming up, or did you want to add something?
No, let's move on.
Okay. So we've talked a lot about going to other states, but during this pandemic, we've also run across a lot of issues with remote practice. And so we wanted to touch upon and talk about a little bit, what are the ethical considerations that come up in connection with that? And the first one I'm going to talk about is technology. And here we are sitting on Zoom doing yet another presentation. We have all had to learn a phenomenal amount of technology. And to do anything in court, they may use various different programs. Some courts are on Zoom, some are on Microsoft Teams, some are on Court Call. Any given day, you may now, sitting in the comfort of your own home, use a bunch of different technologies. And the most important thing is that you understand how they work. And that seems simple. I love technology and I am always an early adopter of everything. But it's very, very important to understand exactly how it works and for your client to understand how it works. Because it's great if I know how to use Zoom, but if my client doesn't understand it or can't do it, then I've got to figure out another effective way to be in communication. And it's ironic to me now how many people have meetings on Zoom, which typically I would just use the phone. But I think we've all started doing that because we're kind of isolated. But I think that understanding technology, very, very important consideration. It is a matter of being a competent attorney practicing during the pandemic. Rachelle?
Yeah, and I think I'm on the opposite of the adoption of technology. But I think, as Carole mentions, we've all been forced to adopt new technologies, but also working remotely raises other concerns of your security, of your, and we'll get into that. But that's where, knowing the technology, I would sort of, I'm never going to understand how all this stuff works behind the scenes. And that's not the expectation on lawyers, that they really understand what the computer's doing, behind what we see in the code. And maybe some of you have that ability, but I don't. And the rules don't require that. They require you to, either understand the technology you're using and have an idea of that it's protecting information, that sort of thing, and effective for your communication, or seeking that help, that technology help, to understand whether what you're using is suitable and protective.
Did you want to go ahead now, Rachelle, and jump into confidentiality?
Sure. So again, I believe we put in the materials a California State Bar opinion on virtual law practices. So, this issue is not new. That opinion is from 2012, I believe. And so this was discussed in that opinion. I think in that opinion, because at that time, it was, from my memory, pretty unusual to have a totally virtual law practice. Whereas nowadays, I think even before the pandemic, there already were more people operating virtually. And certainly now that the pandemic is here, a lot of us are operating remotely or virtually, even though we might still have offices that are closed, physical offices that are closed. So that opinion talks a lot about the systems that you're using, the technology that you're using, and making sure that it's protective of security. And I think that's something that now has become fairly standard in many of the programs that are targeted toward lawyers, in law practice management systems, that sort of thing. It's standard to have protections in there that are comport to lawyers' ethical requirements of keeping information from being disclosed, from being able to be targeted in a cyber attack, that sort of thing. And not that there's no way to remove any risk, right? Even if you have a personal server in your office, it could get broken into and information stolen. So there's no perfect here. But there are standards in the industry and in the technology industry that's targeted toward legal services. And so, not to say that there's no requirement on the lawyer to look into that. So there is still that requirement to either look into it yourself if you are knowledgeable enough or gain that knowledge that you can evaluate the technology that you're using or the cloud-based software, whatever it is. But then there's or seeking that advice from a technology expert or your IT consultant. But I think that the industry has changed since that 2012 opinion, where that's more baked into the products that you're going to see.
And thankfully so. At the same time, data breaches are an epidemic with lawyers and law firms. So obviously that means two things. Identity theft is, it's ever changing. Ransomware, phishing schemes, all of that is just ever evolving. We can never keep up, but we have to continue to do the best we can and do what is reasonable, in the words of the ethics opinions that are out there, to try to address it. And that is, it's an ongoing evolutionary type of process we're working on.
Yeah. Go ahead, Carole.
No, go ahead.
Oh, the only other thing I wanted to say on confidentiality with remote work is that, and this is something, when you're working in a physical office space, you might have security, you might have a receptionist up front that's blocking or tracking who's coming into the office. And you might lock your doors at the end of the night. There might be security baked in where if you leave, client notes on your desk, there's not much of a concern that they're going to be lifted or seen by the wrong person. Whereas if you're working, from your house where you have roommates, that sort of thing, you want to think about how you're handling your paper. If you take notes on paper, maybe everything's electronic for you, and then it's more securing your computer and making sure, the normal things of having password protection and having it shut down after a certain period of time, so somebody walking by wouldn't see what's on your computer. But that's something that to be concerned about as well, separate from the technology. What's at risk in your new environment of the confidentiality of your client's information?
And that extends to phone calls. When you're discussing something with a client, you need to be in a private setting. And for many of us, this becomes more and more challenging as we have kids at home who are doing remote school. All of it needs to be managed with one eye on your duty of confidentiality. So that continues to be very, very important, even more so as we're working remotely. I wanted to touch upon a couple of hypotheticals, which I think are based on real situations that have come up to me to address very, very directly what happens with illness during the pandemic when my litigation is ongoing. And one example is your case is set for arbitration or maybe for trial. And it is going to be an in-person case. And your client, who is a key witness in the case, is ill and has COVID and needs to be quarantined, or maybe it's even more serious than that. What can you do is the question. Another scenario that has come to me is on the eve of trial, your key paralegal, who really knows everything about the entire case in a way that nobody else really does. And the case is going to trial. It's a big case, complex litigation. The paralegal is disabled by illness. And let's say it's an arbitration and it's set to happen momentarily. And then the last hypothetical, what if you are in a category that is at risk for illness? You could have some pre-existing condition, maybe you have asthma or something like that, or you're at the age where you shouldn't be in public. You shouldn't be gathering, period, because the risk to you is so significant. And your matter is scheduled for a live arbitration, and the arbitrator is saying, we're going to go forward live, maybe even when the local or state laws or rules or ordinances have prohibited that. So you're in a tricky situation here, needless to say. And Rachelle and I wanted to talk a little bit about what are your ethical duties in this kind of, or these types of different scenarios. And so Rachelle's going to start off by talking about competence. And what does the duty of competence mean when you're in a scenario like this?
Yeah, so the duty of competence requires us, and lawyers have a duty under Rule 1.1 to not intentionally, recklessly, with gross negligence, or repeatedly fail to perform legal services with competence. Well, what is competence? That's defined in 1.1b as the learning and skill and mental, emotional, and physical ability reasonably necessary for the performance of the legal service. So, in an ideal world, and now that the pandemic has been going on for a little while, you can evaluate your situation before you take on a representation. Am I in the position where I can give, first of all, the learning and skill? That's always something. Do you have if you've never practiced criminal law, you're probably not going to take a criminal case unless you can have a lawyer that's assisting you, right? That has the right knowledge. But then secondary, do you have the physical and mental ability an emotional ability to take on that case. And Carole mentioned, having kids on Zoom doing class. Well, are you going to be able to focus enough attention? Are you going to have the emotional bandwidth and the mental bandwidth to be able to represent your client? That's something that should be thought of before you take on a representation. And then one other thing that I wanted to, the other rule that sort of complements the rule of competence is the rule 1.3, which is the diligence rule. And that's diligence is that a lawyer acts with the commitment and dedication to the interests of the client, and doesn't disregard or neglect or unduly delay a matter interested to them. So that's also, the idea that you are able to represent your client's interests and that your own personal matters, whether it's the fear of illness or things like that, are not going to get in the way.
So I think, bearing in mind your duty of competence, the next thing you're going to have to think about in these hypothetical scenarios is your duty of communication. You really are obligated to connect with your client and to consult with your client regarding these situations. This can get a little bit tricky, and especially where you're talking about the health of a witness, a paralegal, or yourself, because there is a right to privacy regarding health related matters, but you're going to have to give your client enough information about the situation in order to make a decision as to what is the best course to pursue. You're also going to need to advise the client of any limitations on your own conduct, and that may be due to your own health. That may be due to the restrictions that may be in place in your jurisdiction that you may need to tell your client, I cannot attend the live arbitration because that would violate the law in my area. I don't know about Los Angeles. In San Diego, they are doing some degree of enforcement of the pandemic related restrictions on live gatherings. And so, you've got to take that type of thing into consideration and give the client enough information in order to allow the client to make an informed decision about, what are their options in going forward. Rachelle?
Well, I want to, there was in the chat a mention by an arbitrator that said if the local order says you can't meet in person, they can't imagine ordering everyone to come in person and not just doing the arbitration in Zoom. And I would expect that to be the case. But what I think is interesting is if local rules allow for an in-person meeting, but the lawyer still doesn't feel comfortable, so COVID is out there. Some jurisdictions are saying because of that, we're shutting everything down or we're moving to Zoom for these purposes. But there's some amount of in-person still allowed. And then there are some jurisdictions where there's more in-person allowed, but that still doesn't mean that the lawyer would feel comfortable going in person. And so one of the materials that we provide is a New York City bar opinion that looked at that question of what if a lawyer, because of either their own health reasons, maybe someone in their family that they live with, that they don't feel comfortable going to court, can they withdraw? And I think this was the one where it talked about withdrawal of once you're representing a client and you have to go to court, can you withdraw? And that's, so Carole, your example brings that up as well. If you're in it and you have to go to court, whether, the local orders might allow for that, but you might not feel comfortable. And the answer is maybe, like so many things that we look at. But if you look at Rule 1.16, the way that lawyers can withdraw, a lawyer would have to withdraw if they can't, if their representation would violate the rules of professional conduct. Now, how you get to that, and this is discussed in this New York City ethics opinion, how you get to there is by, if you have a conflict because of your personal interest. So you are afraid to go to court, that might make it so you can't competently represent your client. And then you'd be violating the rules if you continued that representation. So it's possible you get to that level where there actually is, would be a violation of the rule to continue to represent your client. It might be there's a permissive withdrawal if it's likely to lead, if the representation is likely to lead to a violation of the rules. So that's, where you're not really sure. Maybe you can competently represent them, but you're not really sure if it goes to trial. And some of the things that the New York City bar opinion brings up are examples of how you could be limited from providing competent services, where you might, let's say, accept a settlement or encourage your client to accept a settlement that you might not otherwise encourage them to take because you don't want to go to trial. So there are real impacts on how you might be able to represent your client, and it's all going to be fact-based on the situation.
And Mr. Grossman, you seem like a really reasonable arbitrator, since you're saying you cannot imagine it, but I have had a couple people indicating to me that you must not have been arbitrating their matters. So, I think arbitrators, they want you to go forward with the case, right? Everybody's ready to go, everybody's prepared. And yet, with all the people involved, somebody can get ill and not be able to go forward. Part of the withdrawal rule also talks about the lawyer can withdraw, meaning it is permissive, where the lawyer's mental or physical condition renders it difficult for the lawyer to carry out the representation effectively. So if you're ordered to do something live and you cannot because of your physical condition, whatever it may be, illness or risk of illness, then you have the right under the rule to seek to withdraw. Now, again, you're going to need to have the tribunal's approval for that if you're in front of a court, or if you're even in front of an arbitrator, and they may not approve it. But you're going to need to confer with your client and make the request. And maybe you make a request for a reasonable continuance for the period of quarantine or whatever the situation would call for. And maybe the court or the arbitrator grants it, and you're fine. And if not, alternatively, if you're ordered to be in person and you can't, then your only alternative that you're left with is to seek to withdraw. You can withdraw if your client agrees. And if your client does not agree, then you're in a situation where you can still ask the court to allow you to withdraw, but your client may be able to weigh in as well on that, and may be able to point out the contrary reasons why you shouldn't be able to withdraw. And then the arbitrator, the judge, the court is going to have to go ahead and make a decision on that. When you're in this situation, you have a conflict of interest. And so the conflicts rules apply, and it literally is the interest of the lawyer that conflicts, the individual lawyer that conflicts with the interest of the client. The client may want to go forward. But so whenever you have a conflict of interest with your client, you are in violation of the rules unless the client waives that conflict after informed consent, after they've been advised of what the situation is. If your client does not waive the conflict, then you are in violation of the conflicts rule, and withdrawal would be mandatory. whenever you're violating a rule, then you can't do that. You have to withdraw from the case. So this is part of what is addressed in the New York State Bar's opinion. And I got to hand it to him for getting a couple of opinions out of New York during the pandemic, which we can actually point to and talk about. We don't have any California ethics opinions addressing the pandemic that I'm aware of. But maybe Rachelle and I will try to work on that on the California Lawyers Association Ethics Committee. But short of that, you can always get guidance from an ethics lawyer if you are stuck for what to do. These are some tricky issues to navigate. You obviously do not want to abandon your client. That is a violation in itself. If you withdraw and cause harm to your client, you're putting yourself at risk. But sometimes there's just not a lot of good choices. And so you're going to want to consider everything carefully, consult with your client, get counsel if you need it, and then try to pick the best path you can. Rachelle, other thoughts or comments?
Yeah, I think that's important to highlight, the consulting with your client, because there might be, like Carole, you mentioned things that you might do to ask for a continuance or to request being able to do things online that are being ordered to do live, and those might be completely acceptable to your client to try to push for. They might have the same concerns. So I think you might be concerned that something's going to be a conflict, but it might be that you do share an interest there. And so I think that communication is essential. And you'll learn from that whether you really can move forward and try a workaround, or whether that's not going to work because your client is pushing for a different result that you don't feel comfortable with.
So one thing that's been raised up to me, and we're getting near the end of our time, but I just wanted to throw it out there, is advance consent to how am I going to handle a COVID situation. And some people have been telling me that they're putting language in their fee agreements that would allow them to withdraw from the representation if their health requires it. I think this is still a really developing area. I think there is a comment in one of the rules, I think it's 1.2, which allows lawyers to get advance consent from their client on how they will handle things in connection with the representation. And also to limit the scope of the representation. And so, the comment 2 says, at the outset or during the representation, a client may authorize the lawyer to take a specific action on the client's behalf without further consultation. Absent a material change and subject to Rule 1.4, a lawyer may rely upon such advance consultation. So 1.4 is the rule about communication with clients. So Rachelle, what do you think about this?
Getting the advance consent. You mentioned, and it is in the Rule 1.16 about that you can't withdraw if there's unless you've taken reasonable steps to avoid reasonably foreseeable prejudice. So one concern is that you have this advance consent, but then you're terminating at a point when, and I don't think the advance consent gets you out of that concern, or having to go to the court to ask to get out of the case if you have to get court approval. So I think it does. What I think is nice about the idea of notifying your client is so that up front they can decide, you're sort of limiting the representation at that point. Well, I I can give you this, but I'm not willing to do this. And at that point, the client can make the decision, well, I'm not really comfortable with that. And so I like the idea of putting it out there where your boundaries are as a lawyer, so then the client can decide whether that fits with what their needs are.
Yeah, I agree. Now, I think we have hit the end of our time. Obviously, this is a big topic and we could keep going, but I want to honor everybody's time commitments and the Bar Association too. So do feel free to follow up with us and do take a close look at the materials. I think they're very, very helpful. And it's been our pleasure to be with you all today.
Thank you.